Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Four interesting cases, including one from the highest court in the land, all published on a Thursday. Come at me, courts. Also, another heads up for Ninth Circuit practitioners. The Ninth Circuit withdrew its decision in Enriquez v. Barr this week, discussed on the August 17th episode of the podcast. Enriquez had held, in relevant part, that deferred action pursuant to an approved VAWA petition does not constitute an admission under immigration law. And although the Ninth Circuit did not send the case back on that issue, it did withdraw the decision in its entirety. So, I believe, nothing about Enriquez v. Barr is binding or persuasive authority upon anyone. And with that, here's Kevin. Thanks, Kevin. It's that time of year again, Supreme Court season. First up is Pereida v. Wilkinson, published by the Supreme Court on March 4th, 2021. And the Supreme Court started off with a tough loss for non-citizens on the categorical approach and eligibility for relief. Justice Gorsuch wrote the opinion, and Justices Breyer, Sotomayor, and Kagan dissented, while Justice Barrett took no part in the decision. As often occurs, while the analysis is complicated, the legal question is quite simple. What happens when a non-citizen applies for immigration relief, but the non-citizen has been convicted under a divisible statute that may or may not bar him from relief, but the record is unclear which portion of the crime he was convicted of? Okay, so maybe the legal question isn't so simple. Mr. Pereida is removable for entering the United States without inspection or admission, but is potentially eligible for non-LPR cancellation of removal under INA Section 240A-B. However, he's been convicted of a crime, and if that crime matches the definition of a crime involving moral turpitude, he's barred from relief. Now, Mr. Pereida was charged with violating Nebraska's attempted criminal impersonation statute, now contained at Nebraska Statute Section 28-638. Nearly, if not all, quote, crimes involving fraud as an ingredient, end quote, qualify as CIMTs. But not all the ways to commit the Nebraska offense involve fraud. Only 3 out of 4 do. The criminal complaint indeed charged Mr. Pereida with committing a fraud-type subcrime, and Mr. Pereida never rebutted that evidence, even after he was finally convicted. It appears that no one ever submitted the final conviction documents in court. Here, because the statute was divisible into 4 separate crimes, and because the analysis occurred at the relief stage of removal proceedings, the Supreme Court held that Mr. Pereida was ineligible for relief unless he could show that he was convicted of the 4th non-turpitudinous way of committing the criminal offense. This Mr. Pereida did not do. To reach this conclusion, the majority relied heavily on the fact that the INA places the burden to establish eligibility for relief on the non-citizen. And here, Mr. Pereida, quote, refused to produce any evidence about his crime of conviction, even after the government introduced evidence suggesting that he was convicted under a statute setting forth some crimes involving fraud, end quote. I must reiterate, this conclusion only follows because the Nebraska crime at issue is divisible into separate elements. If it wasn't, and if one of the means for committing the crime was not a bar to relief, even Justice Gorsuch agrees that it would be, quote, a simple thing for a judge to conclude from a defendant's criminal records that he was convicted of violating statute X and thus necessarily convicted of crime X, end quote, and that crime X does not bar him from relief. Footnote 4 also supports this conclusion. So, Mr. Pereida is ineligible for non-LPR cancellation of removal because he didn't show that he wasn't convicted of the CIMT portion of a divisible statute. Obviously, I've got some more. As I read this decision, and please email me if you disagree, the majority has not answered the question of who has the burden to establish, at the relief stage, whether a statute is divisible or not. This entire decision presupposes a divisible statute, as it states many times, and the majority largely avoids the least culpable conduct assumption required by the categorical approach by framing the issue as a question of fact. What crime was Mr. Pereida actually convicted of? Framed as a factual issue, the non-citizen obviously has the burden at the relief stage. But assuming that we know a non-citizen's specific conviction, the legal question of whether that statute is in fact divisible should not be one where burdens matter. Rather, it should just be something that an immigration judge must decide. I don't see the majority's decision altering that. Do you? But bad facts do make bad law. There's no doubt in my mind that the majority did not want to condone a framework whereby non-citizens can withhold information such as their criminal conviction documents and obtain immigration relief. And if nothing else, this decision highlights how important the Supreme Court believes burdens are in removal proceedings. Use it when DHS has the burden, as the majority's case law discussion makes crystal clear. Continuing on this thread, might this decision help challenge the problematic realistic probability case law percolating out of the BIA and the Fifth Circuit? The majority acknowledges that someone, quote, hypothetically could violate the Nebraska statute without committing fraud, end quote. But that because Mr. Pereida has the burden, and only because he has the burden, he can't show that, quote, the statute does not qualify as a crime involving moral turpitude, end quote, in his case, without proving which subsection he was convicted under. But following this logic, doesn't it follow that where DHS has the burden to establish removability, and the statute, hypothetically, and at least when based on the plain text of the statute, as was the case here, shows that the crime can be committed in a non-turpitudinous way, a non-citizen doesn't have to point to an actual case for DHS to fail to meet its burden? Seems solid to me. Next, I see in the various immigration groups that some practitioners are concerned that this decision can be used to bar relief because, taken to its natural extreme, a non-citizen can never actually, after all, produce enough evidence to show that he has not, as a matter of fact, been convicted of a disqualifying crime, because the world is limitless, and some bars don't even require a conviction. But I think that this concern may be a bit too much. My understanding of the case law, and certainly specific bars to relief, places an initial burden upon DHS to identify reasons that a bar to relief may apply before a non-citizen must combat it. And in this very case, DHS did indeed meet its initial burden by producing the criminal complaint. So remember that. And finally, for what it's worth, that I enjoyed reading Justice Gorsuch's writing. And that is Pereida v. Wilkinson. Next is Arita-Deras v. Wilkinson, published by the Fourth Circuit on March 4th, 2021. Here's Kerr and Company pulling off another asylum win in the Fourth Circuit. Here we go. Miss Arita-Deras is from Honduras. She was deemed to have a credible fear of persecution when apprehended near the border, and she and her minor son were placed in removal proceedings, where she brought an asylum case pro se. She based her claim on her membership in a particular social group, namely the nuclear family of her husband, due to death threats they had received from gangs. To support her claims, she submitted her own affidavit, that of her husband and multiple family members, and proof that her brother-in-law and father-in-law were dead. See, Miss Arita-Deras' husband was once friends with a man named Ricardo, who became a local gang leader and then became jealous of Miss Arita-Deras' husband's financial success. The couple moved towns due to the resulting death threats, but continued to receive the threats. A year later, the gang murdered Miss Arita-Deras' husband's brother and brother-in-law, who had remained behind in the town. The couple fled even further away, but the threats didn't stop. And on a family outing with their children, known members of the gang shot at them from a passing car. The gang then killed Miss Arita-Deras' husband's father, wherein the husband and the brother fled to the U.S. The brother even received asylum. The gang then threatened Miss Arita-Deras and her son many times, until they fled to the U.S. too. After listening to all that testimony, the IJ, among other things, found that it didn't qualify for asylum, largely rejected the affidavits as self-serving, and deemed further corroboration necessary. The BIA affirmed. The Fourth Circuit reversed for a bunch of reasons, providing excellent quotes along the way. First, it held that Miss Arita-Deras' inability to identify the gang, other than connecting it to Ricardo, didn't matter, because indeed, quote, a person can suffer persecution without ever learning the names of the individuals who have subjected her to that persecution, and it need not be proved to satisfy the nexus requirement, end quote. Simply put, quote, the actual identity of her persecutor was not an element of either the past persecution inquiry or the nexus inquiry, end quote. Word up. Next, the court found that the IJ violated BIA precedent by categorically rejecting the affidavits, and instead requiring in-person testimony from the testators, notwithstanding the fact that the husband and brother-in-law were physically present in the U.S. And that is, quote, because the IJ found that Arita-Deras' testimony was credible, the absence of inconsistencies between her testimony and her husband's affidavit supported the affidavit's corroborative value, end quote. Moving on, the Fourth Circuit held that the BIA errs when, as here, it requires a non-citizen to, quote, demonstrate that she suffered physical harm in conjunction with the death threats she received, end quote. Death threats alone are sufficient. Finally, the Fourth Circuit held that based on this record, Miss Arita-Deras' family membership was at least one central reason for the persecution she suffered, in addition to other criminal reasons. Quote, if she were not married to her husband, she would not have been targeted with these threats, end quote. Congratulations to Sam Heisch and Adina Applebaum of CARE, and a variety of attorneys from Crowell and Mooring LLP on the win. Here's a bit more. If you still had any doubt based on all the quotes I just said, this case is vital to rely upon when, as is often the case, the only evidence your asylum client has to rely on is her own testimony and affidavits from family members. This case is your warm blanket. Next, in a footnote, the Fourth Circuit didn't even deem it necessary to discuss the IJ's reliance on a State Department report that the IJ believed contradicted Miss Arita-Deras' claim, because the report, quote, is applicable to broader country conditions rather than to Miss Arita-Deras' individual circumstances, end quote. And here's a good quote to use on petition for review to challenge an otherwise difficult agency finding of fact. Quote, factual findings made in the application of an incorrect legal standard are not accorded any deference, end quote. Finally, the Fourth Circuit expressly declined to address family-based particular social groups under matter of LEA II because the BIA hadn't done so. and instead reminded everyone of its, quote, long-standing analysis that a family relationship qualifies as a particular social group, end quote. And that is Arita-Deras v. Wilkinson. Moving along, we have White v. Wilkinson, published by the 8th Circuit on March 4th, 2021. This case involves a motion to reopen from a non-citizen from the United Kingdom, a rarity in published removal defense decisions. Miss White came to the U.S. as a child of an L1 visa holder in 2006. She remained in the U.S. on a student visa, but it appears that she eventually stopped attending school. She became pregnant and married her son's father, who ended up abusing her, resulting in a restraining order that the husband then violated in mid-2017. Shortly thereafter, in a period of just a few weeks, Miss White herself was arrested for marijuana possession, shoplifting, arson, and then theft of a motor vehicle. She was placed in removal proceedings and found removable for having gone out of her status, and sought both regular and special rule cancellation of removal under the Violence Against Women Act, or VAWA. But the IJ denied on both good moral character grounds and discretionary grounds, due mainly to her arrests, her apparently incredible testimony about those arrests, and the fact that she had left her child alone with drug abusers during that rough patch in her life. The BIA affirmed. Eventually, all of the criminal charges against Miss White were dismissed, and so she filed a motion to reopen with the BIA based on this and other alleged new evidence. Now, as an abused spouse applying under VAWA cancellation, INA Section 240A C7C IV provides Miss White with 1 year, rather than only 90 days, to file a motion to reopen based on new evidence. So her filing in this case was timely. But the BIA denied the motion, finding that the new evidence was not actually new, nor was it material. Addressing the dismissed criminal charges specifically, the BIA held that it would not have changed the IJ's decision, because the IJ didn't rely solely on those alleged crimes to deny the relief. The 8th Circuit affirmed, rejecting Miss White's multitude of arguments. It rejected her due process-based claims because, quote, a petitioner must have a protected property or liberty interest to succeed on a due process claim, end quote, and a non-citizen has no, quote, constitutionally protected interest in receiving a form of discretionary relief, end quote. As to the substance of the BIA's decision denying the motion to reopen, the 8th Circuit stated primarily that the BIA properly recognized that the IJ had not denied VAWA cancellation based on Miss White's arrests or pending criminal charges, but rather her testimony about that conduct and other evidence of record. And to the extent that the BIA didn't mention a piece of new evidence in its decision, the BIA did say it reviewed everything, and, quote, the board is not required to name every piece of evidence that was before it, end quote. Miss White's case, therefore, was not reopened. One more thing. I've seen some IJs and the BIA deny ineffective assistance of counsel motions to reopen on similar prejudice grounds as those mentioned by the 8th Circuit here. That is, because an ineffective assistance of counsel motion to reopen relates to an underlying discretionary form of relief, and because such motion to reopen requires a showing of prejudice, no ineffective assistance of counsel motion to reopen claim can lie, so the theory goes, when the ineffective assistance of counsel relates to a form of discretionary relief. But obviously that's not the case, because virtually every published ineffective assistance of counsel decision relates to a discretionary form of relief, which includes asylum, by the way. Without getting too deep into it here, I believe that such an analysis mistakenly ignores the Sixth Amendment underpinnings of an ineffective assistance of counsel claim, which of course are not present in a straight due process-based argument, as was the case here. And that is White v. Wilkinson. Finally, we have Aden v. Wilkinson, published by the 9th Circuit on March 4th, 2021. This is a case about asylum and related relief, specifically firm resettlement, an issue we have yet to discuss on the podcast. Mr. Aden is from Somalia and practices a form of Islamic mysticism known as Sufism. He claims he was persecuted and fears persecution in Somalia at the hands of the Sunni fundamentalist group Al-Shabaab for this reason. And Al-Shabaab is active in his region of Somalia. He first fled Somalia for South Africa, where he was granted asylum and a work permit. To live in South Africa under its asylum program, Mr. Aden needed to continuously renew his asylum. He did so for 4 years, during which time, though, he was the target of xenophobic attacks, including being beaten with sticks by anti-immigrant protesters at a store that he worked at on 2 occasions, which was then burned to the ground. He was also threatened with death by protesters brandishing guns, and when he reported it, the South African police did not act. He fled to the U.S. border in 2015 and applied for asylum and related relief. An IJ eventually denied asylum, finding that Mr. Aden had firmly resettled in South Africa. The IJ also held that Mr. Aden had not suffered harm in Somalia that rose to the level of past persecution, and that he could not establish a well-founded fear despite Al-Shabaab remaining a, quote, major force in Somalia, end quote. But the IJ did grant Mr. Aden withholding of removal from South Africa, based on all the harm that he had suffered there, which simply means that Mr. Aden can't be removed to South Africa, which quite frankly he probably can't be anyway. The BIA affirmed all of it. So, firm resettlement. It's a statutory bar to asylum. It does not bar withholding of removal or protection under the Convention Against Torture. The firm resettlement analysis is governed by 2 recent BIA decisions, which outline a somewhat complex burden-shifting framework. But the first step for firm resettlement is for DHS to present sufficient, quote, evidence that the applicant received an offer of permanent resettlement, end quote, in a third country. If DHS meets that initial burden, it's then up to the non-citizen to show that he qualifies for an exception to the firm resettlement bar. One such exception is where, due to substantial and conscious restrictions by the country's authorities, quote, the conditions of the applicant's residence were too restricted for the applicant to be firmly resettled, end quote. Here, the Ninth Circuit agreed that DHS had met its initial burden. Mr. Aden lived in South Africa with asylum for 4 years. But does he meet the exception? The IJ and the BIA, after all, granted Mr. Aden withholding of removal based on his experience in South Africa, meaning that the agency found that Mr. Aden had suffered harm that equated to past persecution from private individuals, and that the South African government was unable or unwilling to protect him. And considering that, the Ninth Circuit held that Mr. Aden's experience in South Africa met the firm resettlement bar exception. What a case. Digging a bit deeper and applying the firm resettlement elements, the Ninth Circuit noted first that there is, quote, no doubt that persecution is a substantial restriction on one's residence, end quote. Fairly uncontroversial. Next, a restriction is, quote, conscious if the persecutors act knowingly, end quote. Okay, checkbox 2 for the firm resettlement exception. But was Mr. Aden's experience in South Africa, quote, by the government, end quote, within the meaning of the firm resettlement regulations? Well, under Ninth Circuit precedent, it was, because persecution necessarily means that the government cannot protect a non-citizen due to its action or inaction, and, quote, firmly resettled aliens are by definition no longer subject to persecution, end quote. And even government inaction, quote, would still constitute a restriction on living by a country's authorities, end quote. Big stuff. Turning then to the agency's substantive denial of asylum from Somalia, the Ninth Circuit reversed that too. It noted that even with simple beatings, quote, when the incidents have involved physical harm plus something more, such as credible death threats, we have not hesitated to conclude that the petitioner suffered persecution, end quote. And with threats, often, quote, what matters is whether the group making the threat has the will or the ability to carry it out, not whether it is, in fact, carried out, end quote. Mr. Aden's experience in Somalia met this standard because he was physically beaten with his brother in a theater by 10 Al-Shabaab members for watching a movie that aligned with his mystic religion. He was hit with a rifle and forced to hide, and threatened with murder over the phone 2 weeks later unless he obeyed Al-Shabaab. That this qualified as past persecution was supported by the fact that, as the IJ found, Somalia continued to suffer political and social turmoil due to Al-Shabaab, Mr. Aden's persecutors. Finally, the Ninth Circuit overturned the agency's finding on nexus, finding that indeed Al-Shabaab persecuted Mr. Aden on account of his political opinion, religious beliefs, or imputed political opinion or religious beliefs. So this case can be cited to for the proposition that imputed religion is a thing. Congratulations, Emery Al-Habibi, for petitioner. Quite the case. 2 more things before I let you all go. Here's another quote that shows how even threats less than death threats might constitute past persecution. Remember that even minor threats must be analyzed, quote, cumulatively, and, quote, an important consideration is whether the threat leaves the person with no realistic choice but to conform to the persecutor's way of life and forsake other political or religious beliefs or flee, end quote. And so here, and despite the relatively minor beating at the hand of Al-Shabaab, quote, the death threat further left Mr. Aden with the bleak choice of remaining steadfast in his way of life and risking death, or succumbing to Al-Shabaab's demand for conformity, end quote. And finally, by the way, if you have a 2016 Al-Shabaab-based asylum claim, this decision and the country condition evidence relied upon therein arguably stands for the proposition that persecution from Al-Shabaab, as of 2016, rises to the level of past persecution and may support a pattern and practice claim. So check it out. And that is Ali Aden v. Wilkinson. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend, and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate for 5 credit hours, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all. And follow the show on Instagram and Facebook at Immigration Review, and send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.